Public industry includes the part played by the state in private industry as well as the entirely public industries. All private industries are largely dependent upon public activity. All private industries are subject to demands on the part of the state. The state is society acting through government. State activity is conscious and vital. Volitional. 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 In its laws, while private activity is governed by laws which are largely unconscious. State activity is natural, though not as primitive as private activity. Associated activity is displacing individual activity, leaving us only the choice between the state and private cooperations. The state has greater scope, greater power, greater impartiality, and can more readily enlist private activities than any private agency. The state is fitted for the management of interests that are general, extensive, slow in bringing returns, the dangerous as tools as private interest. The state is ill-fitted for management of interests that are sectional and special and require minute supervision. Question: define public industry, private industry. Do they involve different phenomena? In what two ways are private industries dependent upon the state? Define the state. Is two meanings. Which meaning is intended here? Is public activity natural or artificial? Explain fully. What choice is open as to means of methods of industry? What are advantages and disadvantages of cooperation as contrasted by the state? Of the state contrasted with the cooperation, what interests are adapted to state management, to private management? Why? Literature, relation of state and industrial action, problems of today, chapter to the close. Fundamentals, the right of private property. By far the most important economic function of the state is the establishment and maintenance of those fundamental laws which underlie all private economic activity. Only the briefest statement of these is possible within the limits of an elementary work. Private property. This is a right so fundamental in our modern life that we scarcely think of it as a creation of man maintained by constant vigilance on the part of the state and subject to human modification. Still less perhaps does it seem to us a right to open to question. It seems like bedrock and ultimate right, needing no other justification than its own obviousness. If we feel this, however, about the right of private property or ownership, it is only because we are dominated by present and local customs rather than by facts of history or reason. We do not intend to impeach the right of private ownership, but it is a right which may as fairly be called in question as any other, and must justify itself in the same manner. When a custom has obtained very widely and is deeply rooted in human life, there is often a tendency to claim it is a natural right. Quote, by a natural right, men usually mean a right which is arbitrary, which is the right because it is a right, and that's all there is about it. There are no such rights. All true rights are national rights, rights which could show good reason for their claims and can justify their existence on the ground that they promote human welfare. There is no possible basis of human right except human welfare. To claim that the certain rights are ultimate without reference to their effect on society is to beg the question, and has been well characterized, as dogmatism in disguise. It is a characteristic of unscientific and superficial thought to talk much of natural rights. And it is an encouraging sign that in our day such rights are subjected more and more to searching scrutiny. It is therefore a scientist rather than an iconoclast that we should inquire about the time-honored right of private property, beginning of the right. Looking back into history, we discover that first, that private property did not always exist. The savage first owned nothing. Doubtless when we had caught or killed an animal, he considered it more or less his, though even here it was the common property of the family or tribe rather than his own. Beyond this, there were no property rights, as we now understand them. Doubtless, there were struggles for the possession of hunting grounds, but the victor's sense of ownership or right was little better developed than of a victorious lion or buffalo. From these insignificant beginnings, the right of sense of ownership has grown, including more and more articles and dividing up the ownership more and more, until at last nearly everything is owned and nearly everybody owns something. Not until the agricultural stage did land become private property, and the last forms of tribal ownership have not yet everywhere disappeared before individual ownership. Strengthening of the right. The next thing that impresses us is the private property ownership has not always been so extensive or exclusive as at present. We have seen already that the institution of private property has become extended to many things which were at first free goods. It is equally noticeable that the right of ownership has grown intensely in exclusiveness. This is especially marked in the case of individuals whose claims, as opposed to those of the tribe, were at first slight and vague, but they gradually grew, especially in the case of the chieftain, until tribal or communal rights broke down before them. The time was when a Scottish clan has absolute right to the territory they occupied, and no chieftain, however powerful, could have abridged that right. Now there are beautiful tracts of country in Scotland which are most denuded of their agricultural population, because the owners and descendants of these same chieftains have preferred to raise game rather than men on their estates. All are familiar with the general liberty allowed in this country, hunting and fishing on private estates, which Europe is unheard of. Slowly, however, we are beginning to extend our claim to game and fish. Also, the leniency of ownership is disappearing. Limitations of the right by and behalf of the state. Taxation. We next notice that the right of ownership, though tending toward absolutism as between individuals, yet never reaching absolutism, even as between private persons, has never been anything like an absolute right. As regards the guarantee of state, the state has always reserved certain rights over private property, and while other owners have gotten increasing guarantees of protection against their other individuals, they have been obliged to make increasing concessions to the state. Taxation, for instance, is understood today is a comparatively recent right. During the Middle Ages, the right to take private property for the support of state was stoutly resisted, and there was a strong tendency to regard taxation in the modern sense as extortion. It is part of the survival of the medieval spirit which made our forefathers so averse to British taxation, and later to taxation by their own government. Now the right of taxation is universally admitted. This is the first and the most universal and the most serious limitation imposed upon the right of private property and on behalf of the state. Eminent domain and requisitions. The next limitation is the right to state appropriate specific pieces of property with direct compensation to the owner. This is done especially in time of war, when all kinds of supplies are seized and payment made as government sees fit, regardless of the owner's wishes. In time of peace, such purchases are seldom necessary, though the right always remains. In one most important particular, however, this right is in almost constant exercise. This is in regard to land as applied to the purchase of the land. This is known, and the right of eminent domain, which simply means the state's claim to land is paramount. Transactions involving the exercise of the right are not simple seizure, as in this case with taxation, but genuine sales, with this important difference that they are compulsory. These two rights are exceedingly comprehensive. The state may appropriate any portion of the property of its citizens without compensation, so as long as it takes from all alike. It may further buy any man's property to buy any extent at an appraised valuation and without his consent. Limitations of the right by state in behalf of individuals. We now have to notice still farther limitations placed by the state upon the right of property, now not now in its own behalf, but in behalf of individuals. The first is the right to eminent domain, exercised in behalf of the individuals of private corporations. We have seen that the private property has been more and more guaranteed against private trespass. But while the individual is thus prohibited from seizing another's property, he may in certain cases get the state to seize it for him. This is illustrated in the building of railways. Railways in this country are built by private enterprise, but the right of the way is secured by the right of the eminent domain. This is simply necessity, as no railways could be built without it. Added to this is a vast system of legal limitations used to the private property which we are familiar. Nothing is more fallacious than the notion of that right of ownership allows a person to do as he pleases with his private property. Undoubtedly, a man's property rights have often been so defined to admit much abuse, but it has been seen the tendency of the state to so limit the right of to exclude abuses, and such limitations is necessary to secure of private property attacks against attacks. Whenever given a right of private property has to be generally unfavorable to the welfare of society. Government has modified or abolished the right to jeopardize its own stability by failure to do so. Historical cause of private property. If we ask reason of private property, we must distinguish between the two things: the cause of private property in the past and the justification of it in the present. We will still first consider the cause of private ownership. If we take the case of savage who captures an animal, the chieftain who appropriates the land occupied by his tribe, the nation which dispossesses another nation, and ask the origin of ownership in each case, we shall find it consists in conquest of force. Property was owned simply because those who held it had the power to exclude ownership to be right, simply by long continuance. The Normans held northern France at first, but most unjust force. Afterward, by the justice of rights, hardly anyone will deny the original wanton seizure was justified. But surely all will admit that after the lapse of centuries, any attempt to expel the descendants of the invaders would be the grossest of wrongs. But how can a wrong become the basis of a right? Simply by a change in conditions of human well-being. This brings us to the justification of private property. It is not correct to say that a wrong ever becomes the basis of a right. A violent seizure never in itself justifies ownership. Nothing can be more perilous than the ownerships of hereditary rights. To the rest justice of their claim upon its past origin. Few titles of long standing could be traced back very far without disclosing at some point violence or craft of fraud which the moral sense of community would condemn. The dead past should not be urged either in justification or condemnation of existing institutions. They must be judged by their relation to present and future well-being, and by that only. Thus the seizure of Normandy was a wrong. It rudely disturbed the conditions of social well-being. For a similar reason, the later retention of Normandy was right. Human life and had adjusted itself to the conditions resulting from former wrong, and any disturbance of these conditions for the sake of old scores would have been a sacrifice of human well-being and a wrong. Any attempt to rectify the past wrongs, the disturbed equilibrium has been restored, and any attempt to gather up spilled milk. Should private property be retained? Those familiar with socialist doctrines are prepared for such a question, although the modern socialist does not propose to abolish this private property altogether, but only in the instruments of production, as we shall presently see when we come to discuss socialism. In the view of what has been said, the question we may put it in another way: does private ownership promote the welfare of society, not the welfare of owners simply, but the welfare of society as a whole? If it does not, then there can be no question private property should cease. The fact that I have a long owned a thing, and that my father and grandfather owned it before me, is no reason why I should continue to own it. Of course, we should make no changes for uncertain reasons, but if it is clearly proved that my ownership is an injury to society, I ought to renounce my title, and society ought to annul it. This is no place to discuss at length so great a question, but we may mention some considerations of importance. First, there can be no doubt that at a present ownership of private property is the greatest incentive offered to private enterprise. It is by no means the only incentive, for need it perhaps always be the greatest, but that it now is the greatest can be hardly be doubted. The greatest thing in human life is its incentives, and while some incentives may naturally do diminish in importance as new ones develop, to destroy a powerful incentive is a certain disaster. This single consideration, to which many others might be added, in itself sufficient to justify the institution of private property, but inasmuch as private property has always been and must of necessity be limited, the question assumes another form: how much private ownership should be retained? We may lay it down as a general principle, making a present no application of its to details, that is a private property, if a social institution finds its limitations in the welfare of society, as soon as any of its forms or extensions become antisocial, these should be suppressed. Private property in general, specially beneficial, is tending to increase production, although some forms of its decreased production owing to large waste involved. The disadvantage of private property appears particularly in distribution. Although here its effects are partially beneficial, we must never forget the abundance of goods does not necessarily make a people prosperous. If they are so distributed that great goods are devoted to the satisfaction of little wants, and little goods to great wants, then certain individuals may be prosperous, but the majority of men will be miserable in the midst of abundance. That private ownership in some cases tends to do this result can hardly be doubted, and in such cases no justification for it seems possible. An influence of private property on individual wealth. As private property lies at the basis of the existing economic order and its institution, which above everything else determines what share of the total income of society each one shall enjoy, and every modification of the institution exchanges and changes the distribution of wealth, private property in railways explains a large proportion of the mammoth fortunes in the United States. Whether public ownership of railways would have been desirable or not, it is certain it would have been brought with it no such inequalities as private ownership. Even a change in the laws governing the transmission of property from the dead to the living in France brought with it a modification in distribution, decreasing the number of those owning vast fortunes and adding to the number of those enjoying a competence. Private property must be then remembered as the greatest force in the distribution of wealth. Private property is the most important condition of private industry furnished by the state. Like all other human institutions, it is subject to examination and change. Human welfare is the only possible basis of human rights. Private property originated in conquest and force, a fact which neither justifies nor condemns it. The right of ownership was formerly less extensive and less absolute than now. The state has increased the guarantees of private property as between man and man, while asserting more extensively in its own rights of taxation, requisition, and eminent domain. The latter is now frequently exercised in behalf of private interests. An extension of private ownership tends to stimulate production and to concentrate wealth in large fortunes. Questions: why is private property often held to a natural right, not open to discussion? What is a natural right? Quotes: what is the basis of human rights? Are they subject to examination? What is the origin of private property? Does this justify it? Why? What change has taken place in the extent of private property right in its absoluteness? Has the state increased or decreased its guarantees of private ownership as regards other private parties, as regards its own claim? Why? What further extension of state limitations in recent times? Should private property be retained? If so, how far? Why? What is the effect of private property on production, on distribution? How far is the effect in either case beneficial? Why? Literature. The subject of private property in its economic and social aspects of one which has been singularly neglected by English and American writers. John Stuart Mill treats it briefly in Political Economy, Book 2, Chapters 1 and 2. The most satisfactory treatment found in economic literature is that given by Professor Adolf Wagner and his grudgingly Gunder Politischen Economic, by far the best treatment by private property from legal standpoint, with which the present writer is acquainted, is given by distinguished German jurist, the late Professor Rudolf von Thering, in the first volume in his book Zweck and Recht. No one who would be well informed on the subject should neglect to read his masterly exposition. Chapter 3, Fundamentals Guaranteed Privileges, Trademarks, Copyrights, and Patents. Closely connected with the general subject of property is a legal arrangement whereby exclusively privileges are awarded in return for services to society. These privileges become a special form of private property and have a particular significance in the distribution of wealth, although they are not without importance in the production of wealth on account of the stimulus which they give to improvement. Trademarks come under this head. They give property in a design which characterizes the product of a single undertaking as an individual manufacturer, a firm, a company. It is altogether desirable for those who, by superiority of their wages, establish a reputation, should be protected from the contemptible class who, without energy or initiative of their own, attempt to steal the fruits of the exertions of others. It encourages a producer to establish a reputation and know that he can distinguish his goods by design, which others may not imitate. Copyrights and patents. Government creates exclusive privileges by copyright and patent laws, but this is done professedly in the interest of the general public and not of any favored class. Authors and inventors are guaranteed exclusive rights in their productions for a limited period. This monopoly is considered a fit reward for valuable public services. Copyrights and patents have been objected to interferences with natural liberty, but they appear to have justified themselves in the stimulus which they have given to authorship and invention. It must, however, be remembered that all intellectual effort is an historical product. The telephone, for example, did not spring from the mind, one man from Minerva, from the head of Jupiter. The telephone was preceded by a century of scientific invention and discovery, most of it poorly enough remunerated. The telegraph was similarly the result of generations of careful plodding industry of scores of men. Professor Henry of the Princeton College, whose services in connection with the completion of the telegraph were most distinguished, conscientiously refused to take out any patent. It also happens that several persons, almost simultaneously and independently, make the same discoveries and inventions. Now, if the man who makes the finishing touches, which lead to utilization of a long line of work alone, is rewarded, it is like paying only the workmen who put on the roof of the house. It is not generally understood how serious an interference with liberty patents are. A man who has a patent is allowed to say that all the rest of the world be, quote, because I have first done such things, you must not do them, quote. Yet there may be those who about the same time, without any knowledge of him, had found out to do them. When a principle existing in nature is allowed to be patented, and not merely the application of the principle, the interference with liberty becomes still stronger. The practical conclusion is somewhat like this. Patents, like copyrights, are beneficial. Experience seems to warrant this assertion. Patents do not, however, rest on a strong basis of copyrights, because no two persons could ever write precisely the same book. And the fact that I have written a book in no wise keeps you from writing any book you please. Yet even intellectual effort is largely social product. No great author gives the world what was merely evolved out of himself. On the contrary, some such as one lets an age speak through him. The principle which should govern copyrights is a clear one. It is to give the author a reward for his services, not to give persons a reward for services which others have performed. As has been said well, were not copyrights limited, we might now have a Duke of Shakespeare, delivering a large income from the services of a man who lived 300 years ago. Patents should not be granted on a light of trivial grounds and periods for which they are granted ought to be strictly limited, and subterfuges for the invasion of this limitation ought not to be suffered to succeed as a present. Moreover, owners of patents ought to receive their patents on conditions which will compel them to use them or allow them to lapse. Also, to grant others the right to use the patent on payment of a reasonable royalty. It has also been found beneficial in some countries to lay an annual and perhaps slightly progressive tax on patents, so that those which are not important or not used to may interfere with industrial progress, for its condition that non-payment of the tax works forfeiture of that patent. Laws ought also to be changed so as to prevent such an abuse of patents as we frequently witnessed in our rural districts, where farmers have been induced to infringe patents unwittingly in order that damage might be collected from them. The suggestion of a farmer commissioner of patents that the right of the purchase of a patent reversed by the United States is to be condemned. Our patents at the present time promote monopoly and in some cases interfere senselessly. It is to be feared with manufacturers that the patent laws require to be simplified and amended and their abuses removed. At the same time, reward should in some way always be provided for those rights who make valuable inventions. The right of contract. Scarcely second to the right of private property, the right of contract is the maintenance of value, of which we are equally dependent upon the state. Some sort of contract lies at the basis of associated activity. To secure the conditions of such activity, two things are necessary. First, that men should be allowed to bind themselves, and second, that they should be compelled to respect the agreement thus entered into. Both these are secured by the activity of the state, and such a condition of associated activity among men should be maintained can hardly be doubted. But it has too its limitations resting here as everywhere upon human well-being. Limitations upon the right have been known in varying degrees in different forms from the earliest time. Legislation prescribes under what forms and conditions contracts shall be valid, and declares that under certain circumstances contracts shall be null and void. Experiences have shown the necessity of this. Children, for example, cannot make valid contracts, for they are not presumed to have requisite knowledge and judgment to protect themselves. Contracts which are clearly exposed to public policy are invalid. A contract whereby a person should sell himself into slavery would not be binding. Yet the rule is validity of contracts, its validity. I just like to twist those words. The right to establish the private enterprises is closely allied to the foregoing. To the right to manufacture, sell what and when one pleases is comparatively recent one. It has usually been greatly limited by despotic governments and has the right to be made a matter of sale on the purpose of raising revenue. Most such limitations have been of nature of abuses, and our own time has seen the abolition of an immense number of hampering and vexatious restrictions designed for the plunder rather than the promotion of private enterprise. Restrictions still exist, however, especially on the liquor traffic, which is subject to severe limitations. In this case, there is, of course, a special reason for it. There is a room for question whether entire freedom as the establishment or private enterprises is wholly profitable, even in other cases. The tendency is often to multiply the number of competing concerns far beyond the point of greatest efficiency, and so to maintain a numerous body of poorly paid toilers and expensive service for society. Personal liberty, including the right of movement and acquisition, is a right slowly acquired by society. It is not and never was and never can be an unlimited right. So long as men touch each other in society, they must limit each other, or the liberty of one becomes the slavery of another. It is an endeavor to the state to equalize human liberty, not to make it absolute, for this is impossible. The question is not whether we shall limit liberty, but how we could so limit it in each to secure a maximum liberty to all. Here most of all we hear men talk of, quote, natural rights, When it is proposed to abolish the sale of intoxicating liquors, it is urged that men have the right to drink what they please. When a man becomes a pauper, a payuper, fuck it, through drink, he claims that he has a natural right to live, that society owes him a living. If he leaves a helpless family at the death, the same claim is made for them. Strange that men so seldom think that society has natural rights of self-protection against those who prey upon it. Liberty is indeed a great good, but we must freely submit to restrictions upon liberty, even for the sake of liberty. For the maintenance of these fundamental conditions of private enterprise, namely private property, liberty of contract, liberty in the establishment of enterprises, and liberty of person, we are dependent upon the state. No other instrument of society is adequate to this task. Self-help in these matters, in a narrow sense of self-help, opposing self-help to government activity, is not only insufficient for most of us, but when we exercise by the powerful who prefer it, is pernicious. There is a tendency of vast corporations in the United States to self-help in protection of property, supporting armed forces to this end. This sort of self-help is the beginning of anarchy and tends to bring us back to a condition of semi-civilization. Fortunately, legislation is restricting the right to self-help in these cases. This is a point on which there is virtually no disagreement. The maintenance of these fundamentals, if they are to be maintained at all, can be accomplished in no other way. When the state attempts this and a little more, and its policy is said to be passive, without activity, production in its present form would be utterly impossible. And yet there is a sphere is so restricted, we cannot say that the state participates actively in production as the word is generally used. This passive policy is also called the laissez-faire, or let alone policy. Summary: trademarks, copyrights, and patents are privileges guaranteed to inventors, authors, and reliable manufacturers to reward the stimulate their efforts. All such efforts are largely social, however, the rights conferred should be compatible with social interests. Patents should be more stringently limited than now on account of their exclusive and largely fortuitous character. The right of contract is a condition of private enterprise furnished by the state. Like the right of property, it should be preserved and limited. The right to establish private enterprises, formerly much limited, is now approximately free. It may require some limitation. Personal liberty, including freedom of movement, is a right slowly acquired and subject to some inherent limitations. Questions: what is a trademark? A copyright, a patent, which is most clearly justifiable. What dangers attend the issue of patents? Do they apply to copyrights as well? Why?